rise. The Court of Appeals Division 1 is now in session.
Morning. Thank you. Please be seated. This is the time set for oral argument in 1 CACV 18-0057 Ode et al. Versus Trustee Arizona Bank and Trust. Counsel, each side is allotted 20 minutes for oral argument. Appellant may reserve a portion of that for rebuttal. If you wish to do that, counsel, please keep track of the time using the podium clock. Out of respect for counsel and the court, I ask that those in attendance please make sure that you turn off your cell phones or that they're on vibrate. Counsel, we have read the briefs. We have conferenced this case just this morning. We encourage you to keep that in mind when you present your oral argument today. The proceedings are being recorded and posted to YouTube. Before you begin your argument, please state your name and the party you represent. With that, we will start with counsel for the appellant. You may proceed.
Morning, Your Honors. May it please the Court. My name is Mark House. I represent Chris, David, and Stephen Odie and Norman Keon. Given Your Honor's statement that you've already briefed the case and conferenced the case, I'll keep the factual allegations to a minimum other than where they're needed to further explain the record. We freely acknowledge that we are asking for a significant expansion of the constructive gift theory in terms of how my clients are entitled to receive anything from the estate of Rita Odie. As Your Honors are aware, Mr. Odie was held captive in Iran. After his death and after Rita's death, Congress enacted an act that allowed compensation to be received from foreign states that sponsor terrorism. To that end, Robert Odie's estate was entitled to receive compensation from through that act. And Rita's estate was as well as a separate action, not through Robert. She actually maintained her own. Norm Keon, as the personal representative of the estate, filed that claim, bearing in mind that the nephews had given notice to Arizona Bank and Trust on a couple of occasions that they needed to pursue this claim, and they never did so. So the nephews opened up an estate, filed the claim. The theory that we're actually operating under here in terms of how the nephews are entitled to receive anything is under a constructive gift analysis. Rita gave the nephews nearly all of the hostage-related assets, as we've called them, in 2008 prior to her death. Therefore, at her death, she didn't have any assets that were left that were related to that would have been related to the hostage affair. So, at that point in time,
Counsel, wasn't it just everything that she gave at that time? Wasn't it just tangible, physical assets?
Yes, Your Honor. On the one hand, it was tangible assets. On the other hand, it's everything that was related to the hostage crisis.
I mean, couldn't she have, at that point, signed over rights to life stories? They could have, she could have given some type of documentary evidence of intent to give. Even not even realizing that the Congressional Act had not been passed at that point, she could have said rights to lawsuits against Iran. She could have signed over things that were at least plausible.
Your Honor, taking the last example of the rights of a personal injury action against Iran, we don't believe those are assignable. So without some specific act, I don't think that's an assignable cause of action. So we run, and honestly, I don't think anybody thought about it. In terms of the rights to his life story, I don't think she had those rights to begin with. The boys could have written their own version of those events, and I don't know that would have been prohibited under any type of existing law. So I'm not sure that she had anything else that she could give. The only evidence that we have is that she gave everything related to the hostage crisis to the nephews, and subject to
nearly all.
Nearly all. There are some items that were given to the Jimmy Carter Library, and I believe the Library of Congress. I may have missed one of those items, but the vast majority of the items went directly to the nephews for because they were the family of Robert Odie, and they were, of course, very close to their uncle. Robert didn't have any children. Robert and Rita didn't have kids, so this was the closest thing he had to family outside of his spouse. His estate passed the intestacy to her, and her estate was left to a trust that was ultimately left to charitable beneficiaries, none of whom received any of the assets when they were given away by Rita back in 2008.
What should we make of the Sixth Amendment to her trust? Because it seems to me, as I read the record, that after she made the gift of the property, she then at some point decided to amend the trust because the nephews were named as beneficiaries of the trust, and she disinherited them. Why isn't that kind of relevant to our analysis?
Your Honor, I don't know that she actually ever disinherited. I don't think we have that in the record, that she disinherited them from the prior amendments. The nephews, of course, are not related to her at all from a legal standpoint. So I don't know that we can read a whole lot into the Sixth Amendment. I'll confirm that in the record, but that is my understanding.
Yeah, please correct me if I'm wrong, but my recollection is that the Sixth Amendment, at least, if it didn't explicitly disinherit them, but it changed the beneficiaries of the trust. Right?
Correct. It named the 8 charities as the beneficiaries of the trust. I don't believe we have the prior versions in the record.
Okay.
So whether and as I sit here today, I don't know what they are. But more importantly, they're not part of the appellate record, so I'm not sure that they would matter anyway.
Fair enough, thank you.
Not to belabor the point, but I mean, this is really the crux of our argument. The rest of the issues that are raised in the appellee's response brief with regard to who gets the property, whether we have any other theory upon recoveries, is not really being raised. Our theory on why we're entitled to a recovery is that we want to be able to go back to the trial court and prove, by whatever standard of evidence this court decides, whether my clients are entitled to under a constructive gift analysis. And as I stand here, I freely concede there was nothing in 2008 to give. So we are operating under a unique set of facts, because in 2008 we don't have an asset that she could give. There's no race to actually gift. But if she had actually owned these assets in her will at the time of her death and had left the assets in a will or left the assets in a trust to the boys, then we could make a claim under an after acquired property analysis and reach the result that we're actually seeking. And it just seems a little odd that we can't reach an equitable result, which is how the probate court sits. It sits as a court of equity. That we can't reach an equitable result that applies the same type of analysis. You're not constrained by what the existing law is, because there is no law. There's no law on this particular topic because it's never come up before. And so I'm sorry, Judge Morrison.
No. Let's say we were inclined to say this situation is unique enough to merit an expansion of the constructive gift type of analysis that courts have traditionally undertaken. Could she have made, let's say that we went that way. And as I read the federal statute, it says it goes to the personal representative. So did she have the ability to even gift this and kind of, it seems like we're almost preempted by what federal law says.
Well, the federal statute just says that it goes to the personal representative of Robert's estate. And Rita, as the intestate beneficiary of Robert's estate, would have received everything from Robert's estate. We are actually arguing that this would come from Rita's estate. So it would go to the personal representative of Robert's estate, be passed down to Rita through the laws of intestacy.
It's not intestacy because there is a will that says that
Robert's estate is being administered as an intestate estate. Rita's is not.
I'm sorry.
Robert's is being administered as an intestate estate. I reconfirmed that's how we opened it this morning. And so everything in Robert's estate would go to Rita, and that's compliant with the federal statute, no doubt. The question I believe that you'd asked kind of preceding that was, assuming that had happened, would she have had any ability to assign those rights at the time? And without knowing that the statute is in place, I don't think you can. I think we really have to look at a complete constructive analysis. I don't think she could have done this even if she wanted to, other than creating some right in a will at a later point in time. And that's the argument that I'm really trying to get the court to adopt, is we shouldn't be differentiating simply on timing. If this could have been done under her will, and she could have given all the property to the nephews, I apologize, I call them the boys, they're older than I am, that she could have given all the property to the nephews in her will through her estate plan, and this would have then been included. But the fact that she gave it prior to her death, under existing law, precludes the gift from ever taking place. And that's the doctrine that I would like to see expanded, because that constructive gift piece is what we're trying to latch onto, of she should have been able to do during lifetime what she could have done at death. And that's consistent with the entirety of the way we interpret, testamentary intent. So that is the argument that we're trying to get to, and the court can establish whatever level of proof is necessary to establish that particular claim. And Your Honors, I'm happy to answer any questions, but that really is the crux of our argument. So unless you have any questions, I will reserve the rest of my time.
Thank you, counsel.
Okay, thank you.
Mr. Burke.
Good morning, Your Honors, and may it please the Court, Kent Burke, on behalf of Arizona Bank and Trust, the trustee and personal representatives of the trust and estates of Robert and Rita Odie. There is no justification for expansion, let alone this broad extension of the limited, very narrow constructive gift doctrine. In order for this court to reverse the trial court, you would have to find in favor of the nephews on at least eight separate issues. One, that Rita can give something that didn't exist. Two, that Rita can give something that she didn't own. Three, that Rita could give something that she didn't even control. The record does include Robert's will, which was admitted to probate in this case. And under his will, he gave all of his tangible personal property to Rita, but the residue to the trust, and Rita, pursuant to the terms of the trust, had the right to amend the trust, as she did in the Sixth Amendment, to give it to the 8 charities. 4, you'd have to find that Rita had the power to make a gift, not just constructively or symbolically, but simply by inference, not even an expression of intent. 5, that the court would have to disregard both Robert's and Rita's wills and the terms of the trust, all of which clearly and unequivocally manifest an intent to leave their estate to the charities. 6, the court would have to disregard the federal act pursuant to which this compensation is payable, and explicitly provides that in the event that a beneficiary is deceased, that the proceeds are payable to the personal representative of the estate. 7th, you would have to find that a claim for personal injury is assignable, which Mr. House just acknowledged. If Robert or Rita were to have pursued a claim against the country of Iran, that was a claim for personal injury, which is not assignable. Well, this act was passed effectively as a substitute for pursuing claims against the country of Iran, because Congress also, I believe, enacted some law that prohibited United States citizens from suing Iran as a result of the hostage crisis. And then 8, you would have to find that the nephew's petition for confirmation of gifts was timely. And if you find against the nephews on any one of those 8 issues, as well as the other issues that are raised in our briefs, then I believe the court has to affirm the trial court. Now, as I said, there's no...
Counsel, what about the suggestion just made that we could toss all 8 of those out and essentially come up with an equitable result?
There has to be some principle of law based upon which to base the equitable result, and there simply is none given the undisputed facts of this case.
What about the fact that, I mean, obviously there was an inclination for the nephews to receive, the mementos, the memorabilia that came, and there was obviously some affection there, or whatever, the relationship. Doesn't that give rise to at least some evidence of intent of she might have done something different?
Okay,
I mean-
it reflects an intent to give the tangible personal property. And let's take a closer look at the doctrine of a constructive or symbolic gift. The nephews rely on 38 Amger 2nd of Gifts, Section 21. They only cited part of that resource in their briefs. It goes on to say that the delivery of a gift is a constructive delivery when, in place of actual manual transfer, the donor delivers to the donee the means of obtaining possession and control of the subject matter, or in some other manner relinquishes to the donee power and dominion over it. So that involves a situation where you have an asset that you can't just pick up and give. Keys to a safe deposit box, instructions on where the money is hidden in a wall, or the keys to a lock of a vehicle or a bicycle that doesn't have a title, something like that. But that's not what we're dealing with here.
It's similar to the Hebrew University case where the books are defined or listed at least, and they're there, but at that point in time they don't want to transfer the books until a later point.
Yeah, absolutely. In that case is highly distinguishable from what we have here. First of all, of course, the books actually existed at the time and were known to exist at the time. There was a memorandum, and then there were many public pronouncements that these books were being given to the Hebrew University. And the Hebrew University case that's cited in the briefs itself cites to a prior Hebrew University case that sets forth much more detail of the factual background. And there was a lot of other events that occurred that the Hebrew University court based its decision that the university was entitled to the entire book collection, including evidence that Mrs. Yehuda had declined offers or requests to give certain items of the collection to third parties, and she said, no, they're owned by the university. We've already given them to the university. We have nothing like that here. There's no expression whatsoever of intent to give the books. To give the compensation under the act to the nephews. It's solely by inference from the mere act of giving part of the collection of memorabilia.
To acknowledge then that if there was better evidence that there might be a fact issue that would preclude the motion to dismiss, motion for summary judgment?
No. And I think that even
if there was a handwritten document notarized that said, handwritten typed, it doesn't matter how it's prepared, but said, and if we ever have funding from the government to compensate us, I want it to go to the boys. Would that not change your analysis?
It wouldn't. And I think that if she had signed an assignment of any claims, or even if she had known that the act was going to be passed or the act had been passed and signed an assignment, I hereby give Robert's rights to recover under the act to the nephews, that would not be a valid gift because she didn't own it. She didn't control it. It was controlled by Robert's will that expressly declared that the residue of his estate goes to the trust, and then from there, you can't make a future gift of money other than by will. Under 142513A, the law only allows a future gift of personal property by a memorandum that's referred in a will, but specifically does not allow the gift of money pursuant to a memorandum unless it's explicitly made in the will. And an oral promise or even a written promise to make a will unless certain requirements are satisfied is not a valid claim. And then, of course, we have the act itself, the congressional act itself, that says that the proceeds are payable to the personal representative of the estate if the beneficiary is deceased. And then the other arguments that we've raised, that a personal injury claim is not assignable and so forth. So even if she had signed a memorandum, all of those other arguments would have made that purported gift invalid. The only way that the proceeds from this act could go to the nephews would be if Robert had left after acquired property to the nephews pursuant to the terms of his will, or Robert or Rita amended the trust with their pour-over wills, pouring over the trust, and then amended the trust to provide that the nephews were somehow to benefit from the recovery under the Act, or to receive some form of monetary compensation, whether it was specifically designated from the Act or otherwise.
Mr. Burke, Mr. House candidly admitted, and I appreciated his candor, that he wants us to expand this theory that's really not, obviously not in Arizona law yet. Is there any other jurisdiction that you have found that countenances what Mr. House is asking us to do in a similar situation?
No, it's a totally unique argument that they want to allow a gift by inference where there is no similarity between this case and the cases where constructive or symbolic delivery was allowed to substantiate a gift. And I suggest to you that if you were to adopt the appellant's position, it would open up a huge can of worms and create a lot of uncertainty in probate law, which is to ascertain and give effect to the decedent's wishes, and that is primarily governed by the written instruments, the testamentary instruments that are executed. If you were adopt their position, you would effectively allow parties to sidestep testamentary instruments simply by saying, and this is not a perfect analogy, a hypothetical situation where dad leaves his child a photo album of all the pictures of the dad winning races, and he owns a bunch of race cars, and he gives the kid a photo album of race cars and his trophies, but leaves all of the race cars themselves to charity. That child would be able to say, well, dad left me the photo album, therefore he must have intended to leave me the race cars. That's sort of what they're saying here, and it doesn't apply. There's no legal support in Arizona or elsewhere.
In response to Judge Brown's question earlier about a court of equity, why isn't there a equitable basis under the law for quantum merit? Maybe isn't the right phrase to use, but almost an unjust enrichment type theory, because it does seem that the nephews were the ones that pursued this, and that the trust was negligent, if not kind of lazy, in declining to pursue this. And it wasn't until the nephews actually did the work and got the recovery headed towards the trust that you guys then said, well, no, we want to keep it now.
So we don't have in the record all the circumstances that Mr. House alluded to. I believe it was alleged in the petition or in response to our motion to dismiss that Norman Keon was the one that instigated the process to pursue the claim for compensation under the Act. If there's any claim there, it would be for the reasonable value of his time in pursuing a claim on behalf of the estate. So some reasonable hourly fee in quantum merit for his efforts, his time and efforts.
Doesn't entitle him to the amount.
Exactly. And they haven't pursued that quantum merit claim. And in fact, they haven't pursued any creditor's claim, which that deadline has long since expired with respect to both estates.
Wouldn't true, but it seems like for an after-acquired property, it would come from the time that the estate becomes entitled to the money, not from the original filing of the.
I think you're right. If there is a claim, a debt that arose after death, then whatever the statute of limitations would be, 3 years or 6 years, depending on whether it's a claim based on an oral or a written contract.
But the timeliness at this point would be dependent upon when the money was payable to the estate, not the original filing of the probate.
I would say that the claim would accrue for quantum merit when the services were rendered without due compensation. So, but again, they haven't pursued that claim, and it doesn't entitle them to the proceeds of recovery under the Act in any event. If anything, it would be just, like I said, some hourly rate for the time and effort that he put into making the application.
Thank you.
Unless you have any other questions, I think I've covered it, and our brief is extensive. So, thank you.
I apologize. we do have Robert's will in the record. We had opened this as an intestate estate because we didn't have a copy of the will. It was later found, so there is a copy of Robert's will in the record. I apologize to the court. A couple of just quick points. This is a completely unique situation, and Judge Bean, you had asked if there were any other cases anywhere in the country that have dealt with a situation like this, and honestly, there's not. We have some after-acquired property that was just never addressed, and I mean, like the Shaw case that dealt with Marilyn Monroe's estate has some of those theories in them. However, we really have nothing where there was a finite gift that was given to somebody that was inclusive of all rights at that point in time, and then other rights were then later discovered. And Mr. Burke argues that this is a significant risk to the probate system, and it's really not. I mean, you could very easily resolve this particular problem and have it with limited precedential value because this is such a unique set of facts. It's just not very often that Congress enacts an act of recovery 30 years after an event, and we just don't see that. So it is a unique enough set of facts that I wouldn't be terribly worried about setting some bizarre precedent that opens the floodgates to litigation inside of the probate world. Kent's analogy regarding the race car is actually ignores one simple fact, in that the race cars presumably existed as of the time of everybody's death. I appreciate the analogy, and coming up with one as you're standing here in front of the court is not easy to do, so I appreciate where he's going with that, but it's just simply not reflective of the situation we have here. And Judge Morris, you actually asked a very interesting question of if Rita had signed a document that had attempted to transfer these as a testamentary document, would it be valid? Yes. At that point in time, this would be just deemed an after-acquired property. That would be deemed to be a codicil to her estate plan, assuming validity and a few other things that I realize the way you phrased it, may or may not have been valid. But assuming that it was a valid testamentary document, yes, you could. And under the 2602, our after-acquired property rule, you could make that disposition. So it's strange that we could have done that as a date of death through a testamentary document, but because she gave away all the assets during her lifetime, we're not allowed to do it. And that's the expansion that I'm asking you guys to make. That's the extension of our constructive trust theory, the constructive gift theory that I'm asking the court to adopt. So, thank you.
Thank you.
Thank you for your brief presentation today. We truly appreciate it. We will take the matter under advisement, and we'll issue a written order in due course. The court will now stand at recess, allow the next case to set up for their oral argument. Thank you.